Okay, so value addition of polity, basically we are not going to cover anything about Lakshmikant now. Okay, so because right now they start asking questions from the governance side regarding like police custody, judicial custody, bailable offense, non-bailable, cognizable, FIR, zero FIR, EFIR. So all these we are going to put together itself. Okay, parole, furlough, these items. Okay, so for example, when it comes to the custody, first important topic we will cover custody. They are always in the news also. So custody are two types basically. We already know there is one is police custody, other is called as judicial custody. Okay. ठीक है. So first actually क्या था, earlier we were having few important law like IPC and we were having CRPC and we were Indian Evidence Act. This we used to have, but from 1st July 2024 से we are having this भारतीय न्याय संहिता, that is called as Bharatiya Nyaya Sanhita. From which date? From 1st July 2024. First important thing, old law has been changed. IPC has been changed to BNS and CRPC Bharatiya Nagarik Suraksha Sanhita, correct? That is Bharatiya Nagarik Suraksha Sanhita. This is Bharatiya Saksh Adhiniyam. Saksh means evidence, Adhiniyam means act. Bharatiya Saksh Adhiniyam, this is BNS, BNSS, and then BSA. So right now we no need to like IPC or CRPC. Okay, and they started from 1st July 2024. BNS basically talks about offense, substantive offense. What is murder? What is kidnapping? Theft? This. BNSS talks about procedure. Whatever the procedure we follow during investigation, interrogation, trial, that is covered under BNSS. And BSA actually talks about proof, means what are the proofs which are admissible in the court of law. Understood? So first is BNS, it talks only about the offense. What is offense is all about, okay? And what maximum punishment is there, what is minimum punishment is there. But whatever the procedure takes place like custody, okay, like FIR, like for example trial, that is covered under B and SS. And what proves evidence they are admissible in the court of law, that is covered under BSA, correct? Bharatiya Saksh Adhiniyam. So first three things you have already covered, correct? Now come back to the police custody. So police custody basically क्या है? For example, whenever someone is going to do the crime, okay, so whenever he will do cognizable offense, we will cover that later. Cognizable offense means whenever there is a serious offense is there. In cognizable offense, police can detain the individual without any warrant. Okay, when police will detain the individual without any warrant, we have covered under article number 22 in fundamental right, within 24 hours person need to be presented before the magistrate. Okay, magistrate will decide whether we need to send to the police custody or in the judicial custody. So this is what we are covering, police custody and judicial custody. So police custody simply means detention of a accused person in police station lockup. Okay, so this is simple, detention of person in police lockup, police station lockup, that is called as police custody. So what is the purpose? Why they lock up in the police station? For investigation and interrogation, for collection of evidence. Clear? So accused is kept in a police station lockup. Police have direct physical control now of the over the accused, direct physical control. Okay, and main purpose is interrogation and investigation, because many of the times police need some time to interrogate the accused person to collect some evidence, because if that person will go into the jail, every time police need to take permission of the magistrate, it is a time taking process. During that time evidence can be removed also, so that is the reason they need that individual, correct? One more thing total police custody, total mean how many days they can lock up that person into police station, that cannot exceed 15 days, correct? So total police custody cannot exceed maximum 15 days. That is the maximum. Understood this? Up now this, like earlier under CRPC, this 15 days you have to take in the first 15 only. Like example, whenever person is detained, so during that time only, within 15 days you have to, okay, ask for the police custody, and this 15 days will be counted. For example, you have detained the person will be sent to the judicial custody, 15 days have been passed, now you cannot ask for the police custody. But under this BNSS, this 15 days can be asked in part also. Like first you have asked for like 5 days, but person will be in the police custody. After 5 days he will go to the judicial custody, again you can ask for in the police custody. But total number of days should not be more than 15 days, but you can take in part also. So total police custody cannot exceed 15 days, but under this BNSS this can now be taken in part, but total is still 15 only. Police custody is clear? Okay, whatever police station you have seen, okay, like my Kolyot police station, Tilak Nagar police station, person will be locked up there itself. Okay, jail, judicial custody means parampara hara jail is there, there person will be locked up, correct? So judicial custody, accused is lodged in jail now, in jail, correct, or prison. So here jail authorities are responsible for the custody, jail authorities, okay. Police cannot interrogate the accused without permission of magistrate. So what the thing is this here is, jail authorities they are responsible. Okay, jail authority they are responsible, and police cannot interrogate the individual without permission of the court. What detention can be possible? Here detention was maximum 15 days. Here detention is maximum 90 days or 60 days. Correct? 90 or 60 days. 90 days when offense जो भी होगा, whatever offense punishable with death, life imprisonment, or imprisonment maximum 10 years. Okay, life imprisonment or imprisonment of 10 or more year. In these cases में, that maximum judicial custody is possible 90 days. In other 60 days. Other offense 60 days. So here also time limit has been set. Done. So now you understood about this 15 days and 90 or 60 days. So इसका मतलब offense जहाँ पे punishment is less than 10 years. At that time 60 days maximum you can put in judicial custody, and 90 days are punishable with death, life imprisonment, or imprisonment of 10 or more years than 90 days. Clear abhi? This bifurcation have been done basically for the protection of the accused only. Done this now. So again we are going to sum up here. So any doubt till here? No. So first important thing is, yes. 10 years imprisonment, is it that he was kept in that judicial custody while your case has come up against him, and now he is in no, for whatever offense he was under custody. So whatever offense he has made, for that what is the maximum punishment is prescribed under BNS? No, no, I got that. So you said that one of the conditions is that imprisonment of 10 or more years. Yes. So is that a record that if a person once he committed a crime, imprisonment, finished his sentence, came out. Okay. But the next time he comes in for some other crime, then no matter what other crime it might be, he'll still be under the 90 days imprisonment. No, other crime is completely different crime then. Okay, if suppose example you are saying that first time he has done the crime, if again he is doing the crime, na, so this is a new crime now. Okay, and one more thing, here again he will be basically imprisoned again for 90 days, 60 days, whatever the time is there, because that is a crime is new now. I get that, but I didn't understand this imprisonment of 10 or more years means there are lot of offenses are there. If you do, you can get maximum punishment more than 10 years, 11 years, 17 years, because life imprisonment does not mean always up to the life only. There are different number of years are there. Yes. If suppose example, if you have done an offense where you can get maximum punishment less than 10 years, then 60 days. Clear this? So duration of the custody under BNSS क्या है? First important thing is कि within 24 hours person need to be presented before magistrate, and this thing is mentioned under article number 22, and one section is also there under BNSS. Okay, 58, section 58. Here also it is mentioned this, correct? Second thing, police custody. Police custody maximum 15 days, and that can be taken in part also. Clear? Next, third is total detention. That can be 90 days and 60 days. Okay, one more thing that confuse is, suppose example person A has done a crime where maximum punishment is death, then he will be 90 days inside judicial custody, but he was actually for 15 days in police custody also. So then 90 minus 15 we need to do, because this is the total detention, it is not only judicial, this is total detention. Clear? So that is the reason we have written total detention up to 90 days for serious offenses and 60 days for other offenses. So in the 90 or 60 days we need to add police custody time also. Understood this? So for example, he was under police custody 10 days, then he cannot be more than 80 days in judicial custody. Clear? Now what is the use of these 60-90 days? Because you can say that when someone has done a offense which is punishable with death, why you are releasing that individual? So 60 or 90 days is basically for the default bail. Suppose example, the police, the officer involved in the investigation, he failed to file a charge sheet before the magistrate, because within these 90 days and 60 days he need to file a charge sheet before the magistrate, but he failed, then accused person is having a right of bail also. So next thing is for default bail, correct? So if police fail to file charge sheet, if police fail to file charge sheet, correct, within 60 or 90 days, within 60 or 90 days, then accused get right to default bail. यहाँ पे accused is having a right, he can ask for the bail. Then accused has right to default bail. Clear? So this is mentioned under again section 187 of BNSS. Clear? So when this day one will be counted, day one be counted from the day of when he was come in remand before magistrate. So for example, yesterday police has arrested, but today they are introducing before the magistrate. So from today only this day one will be counted, not from the yesterday. You can write the days will be counted from the date of first remand. The days will be counted from the date of first remand. Date of the first remand, okay, and not the date of arrest, and not the date of arrest, and not the date of arrest. Yes. This means, for example, police has arrested you today only, but within 24 hours you should be present before magistrate. But that day is tomorrow. They are presenting you tomorrow before the magistrate. So your day will be counted from tomorrow only. But what if the 24 hours has been exceeded? Then already fundamental right gets violated. Okay. Habeas corpus. Clear? So any doubt here? Police custody done. Next is now comes to types of arrest. Okay. So basically two types of arrest are there. First is arrest with warrant. Arrest with warrant. And second is arrest without a warrant. Without a warrant. Clear? So whenever magistrate is going to issue the warrant, then only police is going to arrest you. So this will be applicable in basically non-cognizable offense. Non-cognizable offense. Okay, non-cognizable offense में police can arrest only with warrant issued by the magistrate, and this is with cognizable warrant offense. We will cover what is the meaning of cognizable and non. So cognizable offense which are serious in nature, like murder, dowry death, theft, okay, and non-cognizable like defamation, minor, okay, problems happened. So that will come under non-cognizable offense like defamation. Now next is who can make arrest, because this is very important. Who can make arrest? So arrest can be made by, okay, who can make arrest? Okay, who can make arrest? So arrest can be made by police officer, correct? Arrest can be made by magistrate also, okay, and arrest can be made by private person also. Private person. So this is under section 35, okay. This is under section 41, and this is under section 40. Again, sections are not that important. So police officer, police officers can arrest with warrant and without warrant. With warrant and without warrant. Correct? So wherever warrant is necessary, magistrate will issue the warrant. Okay. In that case, suppose example someone has been issued and they are asking your name, they are asking your address, and you are not furnishing this information, even though offense was non-cognizable, still arrest can be made. Understood? Like defamation case is there. Defamation case is a non-cognizable offense. Here naturally there will be no arrest. But if they are asking your name, your address and everything, you are not giving that information to the police officer, then they have every right to arrest you. So in non-cognizable offense also police can arrest you if you are not furnishing the detail. Understood? And in cognizable offense, definitely police officer can arrest you without any warrant. Done? One more thing is, because यहाँ पे questions can be asked, like in cognizable offense, definitely police need to arrest you. Answer is no. Definitely police need not to arrest you in every cognizable offense. Even though cognizable offense happened, but suppose example you are already a good individual, police is aware about it, or your age is more than 60 years, infirm or women or child below 16 years, okay, then police may not arrest you, because there are some regions police should believe that you will not going to run away. Okay, you will remain there. You, whenever they are going to call you, you are visiting the police station, so police may not arrest you. So answer is, in every cognizable offense police definitely not going to arrest you. Correct है ना? In every non cognizable offense police still may arrest you. Clear this? So it depends on the police. Clear? Abhi, for example, under this BNSS, a new safeguard has been added that earlier was not there. Because earlier, what the thing was there, कि if suppose example, if any infirm person is there, age is more than 60 years, and he is actually accused on offense punishable like less than 3 years only, then police cannot make any arrest without permission of deputy SP. At least you have to take permission of the deputy SP. This new addition has been added, so you can write a new safeguard. Actually, new safeguard क्या है? An infirm person, INFIRM, an infirm person or a person above 60 years, or a person above 60 years accused of an offense, accused of an offense punishable with, accused of an offense punishable with less than 3 years, less than 3 years, can be arrested only with prior, can be arrested only with prior permission, only with prior permission of an officer not below the rank of deputy SP. Clear, Abhi? This is done. So understood about the police. Now comes to the magistrate. Okay, section 41. So here what is the case is, suppose example, when an offense can be cognizable offense, non-cognizable also, is committed in the presence of magistrate or within his local jurisdiction. For example, magistrate was walking in his own jurisdiction, and before his eyes this offense has been taken place. That offense can be cognizable or non-cognizable. Then he may or she may himself or herself arrest that individual, or they can pass an order to any person to arrest that individual. Understood? अब यहाँ पे this thing is not there because this is a non-cognizable offense, because order is rightly coming from the magistrate only, so he can do that. So this is the case is कि you can write when offense is, when offense, so which offense? Cognizable plus non-cognizable both, okay, is committed in the presence of a magistrate, in the presence of a magistrate within his local jurisdiction, within his local jurisdiction, okay, within his local jurisdiction, then he may himself arrest then he may himself arrest or order any person to arrest, or order any person to arrest the offender. Clear? So यहाँ पे मैंने I say that कि in the presence of magistrate, that does not mean magistrate should be present there. So it simply means that whenever he will come to know about this situation, he can take the cognizance of it and he may issue the order. Correct? That is a magistrate. The third is by private person. This is very important actually, because यहाँ तक तो everyone is clear. Yes, magistrate can do it. Now private person. Suppose example, you are actually going on the road. Okay, someone has made some committed offense. There was no police. You have seen it completely. Now whether you can arrest, you are not a magistrate, you are not a police, still you also can arrest that individual, and within 6 hours you have to hand over that individual to the police personnel. So private person also can arrest the offender. Clear? So you can write, a private person may arrest someone. Okay, a private person may arrest someone who commits a non-bailable and cognizable, non-bailable and cognizable offense. Correct? Or suppose example, someone is not doing non-cognizable offense, but he is proclaimed offender. Every time he do such mistakes, at that time also private person can arrest that individual, but private person must hand over this offender person to police within 6 hours. Okay, so you can write, private person must hand the arrested person within 6 hours to the nearest police station basically. Nearest police station. Clear? Abhi? Easy. So this was important, whether private person can arrest or not. Answer is yes, they also can arrest, but within 6 hours they need to hand over. Next is, so who can arrest done. Now comes to what is cognizable and non-cognizable offense. So we can like this, cognizable, non-cognizable offense. So first important thing is this, can register FIR. यहाँ पे can register FIR, correct, and start investigation without any magistrate order. Police can register FIR and can start investigation without magistrate order. एक important thing. So here no FIR in such case. Okay, need magistrate order to investigate. Need magistrate order to investigate. This was the question in the UPSC only this year. FIR can be filed in both cognizable and non-cognizable offense. Non-cognizable, there is no FIR concept. They are having NCR register. Okay, इसको बोलते हैं non-cognizable register. So they will just write in information. They will not file an FIR, but they will ask you to visit the magistrate. When magistrate is going to issue the order, then only police can do investigation. So they will not file an. So FIR has nothing to do non-cognizable offense. FIR can be first information report possible only in cognizable offense. Correct? So here police can arrest without warrant. Police can arrest in without warrant. एक चीज ठीक है. यहाँ पे पुलिस कैन नॉट अरेस्ट विदाउट वारंट, पुलिस कैन नॉट अरेस्ट without warrant. Warrant should be there then only. So this will be usually serious offense actually. This usually serious offense. Clear? Serious offense like for example murder, rape, dowry death, kidnapping, correct? Theft, robbery, these serious case. Or this is normal case, simple like defamation, simple hurt, cheating, minor case. Easy है? So cognizable offense means क्या होता है? When suppose example A stab or kill B in public place, then police can arrest A without any warrant and can start investigation, correct? So that is cognizable offense. Non-cognizable, if A publicly defame B for by doing false statement, यहाँ police cannot arrest A on their own. B must approach the magistrate. When magistrate will issue the order, then only investigation will be issued. That is cognizable. So cognizable means simple cognizable corps act. Simple, you can remember by this way. Cognizable means corps act. Police is going to act on their own. Non-cognizable, no police act, no corps act. Okay? So you can remember by this way. This is done. So cognizable and non-cognizable done. The next classification that we are having, this bailable and non-bailable offense. Again, bailable offense, offense. So first is non-bailable does not mean कि bail can never be granted. First important line you can write कि non-bailable does not mean कि bail can never be granted. In bailable offense also bail can be granted. In non-bailable offense also bail can be granted. Bails are available in both cases. Only thing क्या है कि here in bailable offense bail is right. Okay, and non-bailable bail is a discretionary power of court. Okay, so in bailable offense you can ask as a matter of right, they have to give you bail. Okay, in non-bailable offense they will going to check whether bail should be given or not. So here accused can claim bail as a right. Here bail is not a right, but court will decide based on various factors involved. Okay, so this is granted at the discretion of the court only, correct? Court only. For example, court will check whether you will fly out of India or not, whether you will be available or not. If everything is fine, you are not going to create any problem, you are not going to wipe out any evidence, okay, then court can give bail here also. So this is basically for serious offense. Okay, this is usually for less serious offense. This is usually for less serious offense. Okay, so this यहाँ पे you have already mentioned कि bail is granted basically at the discretion of court only. Court will decide. So this is usually for serious offense. Serious offense. Like again, जो cognizable offense है, cognizable, they will come under this category, and non-cognizable offense, they basically will come under bail offense only. That is the case. Up there are again types of bail are there. You must have covered interim bail, regular bail, anticipatory bail. So what is that? The next is types of bail. So there are four types of bail is there. For example, one is a regular bail. Second is anticipatory bail. Third is interim bail. And fourth is default or statutory bail. Interim bail. Okay. So this is mentioned under section 480 and 483. Again, कहाँ पे होगा this all items in BNS double S में, ठीक है? Anticipatory bail section 482. Interim bail not mentioned anywhere under BNSS. Okay, so this is basically judge made. Article number 21. Default already you have covered under section 187. 60 days, 90 days complete default bail will be available. So not mentioned anywhere, no? Interim bail not mentioned. Right of the judge under article. Yes, they have actually created through various court cases. So first is regular bail actually. This is the most common form of bail is regular bail. Regular bail क्या होता है? Whenever you are going to be arrested, you are arrested already. So your family, what they will do? They will go for the bail only. So that is called as regular bail. So regular bail is the most common form filed after arrest. Okay? When accused is already in police custody or judicial custody. So this is the most common form. When accused is already in police custody or judicial custody, then it will be filed. Correct? Hai? So, here what the thing is, one thing you have to remember, if suppose example offense is bailable offense, then you can take bail directly at the police station also. Police also can give the bail. If it is a bailable offense is there. If it is a non-bailable, then only magistrate can give the bail. Again, this is a difference between bailable and non-bailable offenses. For bailable offense, bail can be secured at police station. Okay, for bailable offense. Agar suppose if someone has done bailable offense, okay, so for bailable offense, the bail can be secured at the police station itself also. But for non-bailable, court only, magistrate will give. That can be session court also, that can be high court also. You can approach. Whenever you will go high court, definitely high court will say that you have to go first session court. So regular bail done, एकदम regular है. Whenever arrest happened, first whenever you are going to appear before the magistrate, you will ask the magistrate for what for? Give sir bail to me. Okay, so magistrate will give the bail if they think that you have not done the serious offense, or still there is no need of to, because you still will be here in the city itself. That is the case. So this is done. Next is anticipatory bail. So anticipatory bail is a pre-arrest is a pre-arrest protection. Correct. So it allow a person to seek bail before even arrest. That means whenever you come to know you may be arrested soon. So again, when you are arrested, then you can apply regular bail. But आप क्या करोगे? You are going to ask for anticipatory bail before even arrest. So it allow a person to seek bail before arrest. It allow a person to seek bail before the arrest only. Okay, before being arrested. So whenever there are a reasonable ground is available to fear for arrest for a non-bailable offence, the person can approach the session court. Okay? Like for example, in case of politicians, whenever any case comes, they go with the anticipatory bail only. Okay? उसके लिए ऐसा नहीं again कि suppose example you are going for the anticipatory bail, then court will ask, by FIR has not been filed, why you are coming over here? Okay, first FIR also need to be filed, then only you can come anticipatory bail. So the thing is that this is not a condition. So one need not wait for an FIR to be registered. Before FIR being registered, still he can ask for the anticipatory bail. Because once FIR has been filed, then the thing is investigative agencies, they will come to know you are filing anticipatory bail. Before your bail is going to pass, they are going to arrest you before only. So that is the reason is there is no need to be FIR need to be filed. Still you can seek for the anticipatory bail. Clear? Is it mentioned under BNSS? Answer is yes, it is mentioned. Okay, so which section it is there? Yes. Again, section no need to remember, but they can ask question whether it is there or not. That's more than enough. Next is interim bail. Yes. Which where? You can both also. Yes. Correct. Interim bail. Interim bail means temporary bail you are asking. Okay. Temporary bail. Basically, whenever your main bail application is still pending, regular bail that is still pending, till that point you can ask for the interim bail. Okay, so interim bail is granted for a short and specific period. It is granted for a short and specific time period. While the main bail application is still pending. So main bail application कौन सा होता है? That can be regulatory also, regular also, that can be anticipatory also. When the main bail application is still pending. So this is basically क्या होता है? Whenever there is an emergency is there, person need medical treatment, and he is the sole caregiver for elderly parents in the family. So just because of that, we can ask for the interim bail. Interim bail is not available in BNSS. Okay, this is completely a judge made only. Clear? And last was, so interim bail. Next is fourth, default bail. That is section 187. और इसको मैंडेटरी बेल भी बोलते हैं. वी कैन कॉल दैट मैंडेटरी बेल ऑल्सो, स्टैट्यूटरी बेल ऑल्सो एंड डिफॉल्ट बेल ऑल्सो. This is accused automatic right to release. Okay, whenever for example legally prescribed 90 and 60 days have been passed and police has not able to file charge sheet, then this accused will be having the right to get a bail. That is called as default bail or statutory bail. Correct? This is already we have. Yes.
All four cases you have to pay some money.
Yes.
All four cases you have to pay some money.
Surety, yes, definitely.
Even in the
Every case, every. Okay. Here also automatically will not be released. You have to ask for it. So here you are having right. If you are not asking, then they will not give the bail. and you remain in the jail only then, correct? This will not be rejected, correct? Because when police not able to file charges, why we need to keep that individual inside actually then, correct?
So, if after 90 days and the police after investigation they don't find anything, can the accused then file charges against the police for?
No, it is depends on the court only. They can provide some compensation. Okay, but there is no compulsion.
No matter what losses
No,
he
but yes,
suffered,
exactly. अभी क्या है, now judges, courts, they are evolving regarding according to the requirement of the people, so they are giving compensation. But definitely you cannot give back those 90 days or 60 days to that individual they have already lost. Clear?
So in the sense that because in some cases, if you are in a job, you get fired from
Yes,
the job,
yes.
and you are the sole. In that case, no matter how much compensation you give, that reputation has been lost.
Not possible then. What they can do? They cannot change
No
the
restitution.
no, nothing. Correct? At least they have left after 90 days. What if, for example, you are not? So that person who was released, he is very happy actually. At least there is no charge sheet. I have not done the crime. I am free now. He is happy in that only. Correct? So bail is done. 4 types of bails were there. Now comes to the FIR, 0 FIR and EFIR क्या है? So first is, what is an FIR? So it is first information report. So it is a written document prepared by the police. This is written document prepared by police. So this is applicable only in cognizable offense. This is applicable only in case of cognizable offense, where police can act without magistrate order. Correct? And someone will going to give information to the police, or police themselves can witness this. So information may be given orally also or by electronic communication. Okay, so information can be given orally also or by electronic communication. Okay, so this was also one of the statement in the UPSC prelims exam. Okay, so if oral, for example, then it must be written down. If it is oral means kya, you will go to the police station, you will going to say these things happened, so you are giving orally only. So this must be written down by the police officer. So if orally, it must be written down and read over to the informant. Written down and read over to informant. Whosoever is giving information, we need to read also to that individual. So who can actually file information? Anyone. So anyone with information, they can lodge an FIR. That means informant जो भी होगा, that person need not to be the victim or eyewitness. Anyone can go and can file the FIR. Correct? So anyone with the information can lodge the case. Correct? It should not be always victim or eyewitness. Anyone can go.
So, sir, does the informant have to be present or can it be anonymous?
Electronically he can provide.
So any like if does the identity of the person
That need to be revealed. That is required. Okay, otherwise what will happen is lot of frivolous cases can be filed then. Police will be busy in that. Okay. So, and whenever FIR has been filed, a copy of FIR must be given free of cost to the informant as well as victim. Whenever FIR has been filed, a free copy of it must be given to the informant as well as victim. Clear है? Earlier ऐसा नहीं था. Earlier this was this कि only this free copy should be given to the victim only. Now it should be given to the informant also under new BNSS. ठीक है? Whether FIR registration is mandatory? Answer is yes. If cognizable offense is there, registration is mandatory. Okay? If registration is mandatory, if there is a cognizable offense. Okay, that was case also. Lalita Kumari case versus state of UP 2014. So it is mandatory. So FIR done. Now next is zero FIR. So zero FIR means that can be registered at any police station. Okay, zero FIR means that FIR that can be registered at any police station. Any police station irrespective of the jurisdiction. Irrespective of jurisdiction. Okay. For example, no matter where offense has been committed. Okay. Zero FIR can be filed anywhere. Why we call zero? Because whenever FIR has been filed, okay, then they will give some serial number to that FIR. Okay. But in zero FIR, serial number will be zero only. That is the reason we call that zero FIR. So zero FIR means no serial number will be given, serial number will be zero only. Clear? Easy? Once it is filed, then what will happen? For example, crime has been done like in Chennai. Zero FIR has been filed in Bangalore. Bangalore police cannot do anything because crime has. So what they do now? The police will transfer the case to the respective jurisdiction. That is the duty of the police. They can write later it will be transferred to the police station that has proper jurisdiction. Okay, later transfer to the police station that has proper jurisdiction. Which then register a regular FIR. Which then register a regular FIR and investigates. Clear abhi? So basically, for example, if women is assaulted, okay, for example, while traveling on a train and gets down at Bengaluru, though crime has been occurred near the Chennai, and then that women can file zero FIR in Bangalore itself. Okay, reason is this because so that time should not be completely wasted there and this investigation not able to start it. That is the reason is anywhere we can file it. So from where this came, Justice Verma Committee report. Okay, so the concept basically coming from Justice Verma Committee 2013. Okay, Justice Verma Committee. This Justice Verma Committee was set up after this 2012 Delhi gang rape case. वहाँ पे crucial time was lost just in finding proper jurisdiction. So there Justice Verma Committee has said we should have zero FIR concept. Correct? So in 2015 Ministry of Home Affairs also recommended zero FIR, especially for a crime against women. So they are also promoting this zero FIR concept. Now next thing is this, whether this zero FIR concept is mentioned in any act or not. So answer, earlier it was not, but now this zero FIR concept is mentioned under section 173(1). See, term FIR is mentioned under section 173 only. First important, entire BNSS में term FIR is mentioned under section 173. Here 173(1) में यहाँ पे mention है zero FIR कैसे, irrespective of the area where offense is committed. Okay, irrespective of the area, irrespective of the area where the offense is committed, where offense is committed. So what is this? Zero FIR only, correct? So zero FIR now has a legal recognition first time, written under section 173. So zero FIR done. Next is EFIR. One more thing is this, FIR has not been defined anywhere. Under a BNSS also FIR not been defined actual meaning. So EFIR क्या होता है? EFIR, electronic basically FIR, allow a person to report a cognizable offense electronically. Okay, so this is basically क्या है? An EFIR, in EFIR allow a person, EFIR allow a person to report a cognizable offense electronically rather than physically visiting a police station. Okay, so section 173(1) expressly permit information by electronic communication. Okay, that is called as EFIR. Okay. Now one more thing is this, when an FIR is lodged through electronic communication, then it is taken on record only when after the informant sign it within 3 days. So 3 days time limit has been given. Within 3 days individual need to sign it also, just to know the identity of the individual. Clear? So you can write, when an FIR is filed through electronic communication, when an FIR filed through electronic communication, it is taken on record only after informant sign it within 3 days.
And the signature is physical or is it digital?
Anyway, only thing is we require identity. Simple, correct? So this is clear abhi. EFIR also. Up for example, next question is, suppose example police refuse to register an FIR, then what options you are having? So in this case, if a station house officer refuse to register an FIR, then we can give information in writing to the SP of that area, superintendent of police, correct है ना? अब सपोज एग्जाम्पल सुपरिंटेंडेंट ऑफ पुलिस से भी बात नहीं बनी, then next is complainant may approach the magistrate. If magistrate से भी बात नहीं बनी, then we can approach directly to the high court then, correct है ना? So that is the cases. But first we need to go these two areas only. So you can write, what if police refuse to register an FIR? What if police refuse to register an FIR? So here section 173(4), it is mentioned, if SHO refuses, if SHO refuses to file FIR, basically in cognizable offense only. Non-cognizable means there is no concept of FIR only. Then complainant may send information in writing, approach SP. Okay. So SP को क्या, he must investigate now if offense is cognizable. So this is mentioned now.
What if this, the offense is committed by the police officer in the resort? Then can the informant directly go to the SP or the?
First you have to go police station only.
Even if that person is the one who has committed.
Yes. See, the thing is this: there is a SHO is available. If SHO is not there, then only. So see, same SHO has done the crime. Okay, at that time you have to go first there. Try, if you go, those will be other individuals. They can write. If they are not taking, then directly you can go to the SP. If SP is also not doing this, then there is a section 175 is there under BNSS only. Then directly go to the magistrate. Okay, so court ने भी बोला है कि before magistrate you have to try SHO and SP first. Directly you should not come to the magistrate. Done this. So FIR, 0 FIR, EFIR. Clear अभी? Next is parole and furlough. Okay, so first very important difference is this. For example, you are giving a punishment of like 3 years. Okay, 3 years, and in between you are giving parole of like, for example, 1 month. That does not mean that you have to jail in only 3 years. Now you have to be in jail because 1 year, 1 month you are outside, you have to be 1 more month in the jail itself. So you are not going to reduce that time. Whatever number of days, number of month you are getting the parole, that period will not be counted as sentence served. You have to serve that sentence. Okay, but in furlough में क्या होता है, whatever the time period you are getting that furlough, that period will be counted in sentence. Clear? This is the one major difference is there. Understood? So here you can write, this is granted for a specific region. Okay, this is granted for a specific region parole. Like for example, there is a marriage, there is a one family member die, you have to attend the funeral. That is parole for a specific region only. And this furlough, no specific region is needed. It is periodic in nature. Periodic in the sense your behavior was good in the jail, so that is the reason you are awarded the furlough. Correct? So furlough, there is no need of any specific region. Periodically it will be available to everyone. यहाँ पे क्या है, the time period not counted as sentence served. The time period not counted. The time period is not counted as served. Clear? It is clear abhi? Time period not counted. For example, Ram Rahim, he is getting multiple times parole. Okay, so that does not mean ki, because there is a confusion in the people, he is always outside only. So that does not mean that is going to reduce the sentence time. If 3 years or 5 years punishment has been, he need to spend proper 5 years inside the jail only, no matter how many months, how many days he is outside. That is completely extra. Clear? Here in full, the period counted as sentence served. Period counted as sentence served. करेक्ट है? अब जो ये होता है parole, this will be granted by divisional commissioner only. This will be granted by the divisional commissioner. This will be granted by the divisional commissioner. This one, ठीक है? And that will be granted by DIG of prison. That will be granted by the DIG of prison. DIG of prison. This parole up to 1 month, but multiple times. This will be applicable up to 1 month, but multiple time parole. Parole will be given up to 1 month, but multiple times. ठीक है? And furlough up to 14 days. Up to 14 days, but limited frequency. But limited frequency. Correct? And this is basically pure discretionary, not a right. This is parole purely discretionary. Purely discretionary. Not a right. That means if I am getting parole, I am not having right. Authority is having discretionary power, they can give or they will not give. Correct है ना? But here in full a conditional right for eligible prisoners. It a conditional right for eligible prisoners. Clear है? Example simple है. Like for example, a convict's mother passes away or his daughter's wedding is fixed, then he will apply for the parole. It is the discretionary power of the this divisional commissioner. Okay, if he grant it, then he will be released, for example, for 20 days. But this 20 days will be again added back to his sentence. Correct? Furlough में क्या होता है? A long term convict basically who has served for the qualifying period of like number of years, he was already there, his behavior was good, then he will be granting 14 days of furlough periodically to visit the family, basically to break this monotony of the jail, because they also know after jail you will go to the society only, so you should know how society is functioning also. Okay, so because of that, that will be given, and there is no special reason is required, and these 14 days they will be counted as a time served only, they will not be added in your sentence. That is called as furlough. Clear? So this is decided by whom? Prison Act. Okay, all these things are decided through the Prison Act. They are decided through Prison Act. Okay, and prison is a state subject. This is a state subject. This is very, very important. It is a state subject. So operational rules for parole and furlough, they come from state prison manuals. Okay, so operational rules for parole and furlough, they come from a state prison manual. Rules, okay, for parole and furlough come from the state prison manuals. So they will be different for different state, because it is a state subject only. Done this? So next will be basically right of persons with disability. A lot of times question is coming regarding the rights of vulnerable sections. So right of persons with disability act. Disability act. Okay, first important, it was passed by parliament. Passed by parliament in 2016. In 2016 and came into force in April 2017. It fulfills India's obligation under United Nations Convention, under United Nations Convention of Rights of Person with Disability. United Nations Conventions on Right of Person with Disability, 2007. United Nations Conventions on Right of Person with Disability, 2007. Disability is recognized. Disabilities are recognized, increased from 7. Earlier disabilities recognized was 7 under 1995 to 21 now. So now disabilities, earlier 7 they were there under 1995 Act. Earlier we were having one of the old act, where total disabilities were 7. Right now it is 21. So for example, in 21 what are the news that means added? For example, acid attack victims. This was not applicable earlier, now that has been given. Correct? Autism, it was not there. It is also came now. Specific learning disabilities like Parkinson's disease also, that was also earlier not under this. Thalassemia earlier was not, that was also added. Okay, then hemophilia was not there, that is also added now. Hemophilia. Sickle cell disease, that is also not there earlier. So these were very, for example, neurological and blood related disease have been added now. Earlier they were not the part of this. Clear Abhi?
Just one. Like remember a year back, year or two back, there was this ruling by Supreme Court where a person who has been incarcerated in prison, he has a right to come out to reproduce, to pass on his lineage.
Yes, yes, yes.
So would that come under furlough or what?
No, that will not see, that is under Article 21 basically, correct hai na? So at that time he can go with parole also, okay, because that is not a matter of right in the sense, okay. So furlough will be different. Furlough will be given to everyone. It is a conditional right. So he can ask for the parole also for it. Clear?
And that one, it is a right.
It is a right under Article 21. Okay. This is done. Next is, so these are the new diseases that has been added under this. Now there is one benchmark disability. Okay, one more thing. What is benchmark disability? So this question was also asked in the UPSC only. This was came in 2016 and came into effect on 2017. That was the incorrect statement. Okay, so that question was asked in the UPSC on this itself. Benchmark disability means someone with not less than 40% of a specified disability. That means someone with not less than 40% of a specified disability. Okay, wherever disability is not measurable, then 40%, that is called as benchmark disability. So they are having reservation also. Okay, so they are having reservation. This was also one of the statement there. That 4% government job reservation they are having, 5% in higher education, 5% in higher education, free education, free education 6 to 18 years, not 14, and 5% in poverty and land schemes. So they are having reservation actually. Poverty and land scheme. Land scheme like land allotment. Whenever government is doing land allotment, at that time 5% will be reserved. Correct? Even for example, Karnataka government has given reservation, okay, in liquor retail shop also now. For example, whenever they are okay giving this liquor okay license, there also reservation is there. 12% reserved for SC and ST. Okay, then liquor wala bol rahe at least this is not social empowerment. This is a liquor selling only. But they have given it. Okay. Now, accessibility has been assured for them. जिसमें accessibility India campaign. So next is accessibility. Accessibility में क्या है? Accessible India campaign. सुगमय भारत अभियान. That is called as सुगमय भारत अभियान. Penalties are also there. So you just remember there is a penalty. If someone is not following that, penalties are there. Which ministry is involved here? Social justice, yes. So ministry is social justice or department of empowerment or department of empowerment of person with disability. Person with disability. This comes under Ministry of Social Justice and Empowerment. This comes under Ministry of Social Justice and Empowerment. This was also one of the option basically. So this is for mains exam also. Next is fifth and sixth schedule. Okay, fifth. What is the difference between fifth and sixth schedule? कवर होगा शेड्यूल में, शेड्यूल 1 2 3 4 they will come under sixth में, correct? Fifth means yes. Okay, so which are those northeastern states? Manipur, Assam, Tripura and Mizoram. Okay, so here first we will cover what is the difference, major difference between fifth and sixth schedule. Fifth and sixth schedule. Clear? Now, so first is article number. Okay, under which articles this comes? So they come under article number 244. Okay, so that is 244(1) and this is 244(2). Simple. Okay, sixth little bit 275 also comes under. So this apply to fifth schedule areas, non-northeastern states. Okay, 10 states. States, 10 million states. This is a tribal areas. Tribal areas in 4 states: Assam, Meghalaya, Tripura and Mizoram. Assam, Meghalaya, Tripura and Mizoram. This is the one difference, correct? इसको बेसिकली शेड्यूल एरिया बोलते हैं. दिस वी कॉल नॉर्मली शेड्यूल्ड एरिया. दिस नॉर्मली वी कॉल दैट ट्राइबल एरिया. ओके, नोमेनक्लेचर में. नाउ हु डिक्लेयर दिस फिफ्थ शेड्यूल एरिया? या प्रेसिडेंट. प्रेसिडेंट, करेक्ट. Declares basically on the consultation of governor. This was question in UPSC Prelims last year 2025 में. Okay, so president. Consultation with governor. वहाँ पे ऑप्शन में they have given chief minister in 2025 UPSC Prelims. ठीक है. Now who declares sixth schedule area? गवर्नर और प्रेसिडेंट? कोई भी नहीं, वो संविधान में लिखे हैं. दे आर इन द कॉन्स्टिट्यूशन ओनली. ठीक है. सो द थिंग इज दीज फोर दे आर नेम्ड इन द कॉन्स्टिट्यूशन ओनली. दे आर नेम्ड इन कॉन्स्टिट्यूशन. क्लियर? गवर्नर ओनली ऑर्गेनाइज एंड रीऑर्गेनाइज. You can write governor only organize and reorganize the autonomous district, okay, within them. Next is key body, tribal advisory council. Tribal advisory council, this is the key body this is having, and this is advisory in nature. जैसे नाम है ये, this is advisory only, नाम ही है उसका. And that another is autonomous district council. This is autonomous district council. Autonomous district council, this is having a real power basically. This is having some real power. Okay, this is having a real power. Then regarding panchayat, in this areas mein panchayat also will be there. PISA, okay, so this PISA act will be there yahan pe. ठीक है. And they govern by councils only. Governed by councils. That means no Panchayat Act will going to be applicable there. So difference you came to know, मोटा मोटा difference क्या हो सकता है? अब now fifth schedule areas in detail we can cover. This is the difference. Now fifth schedule area you can cover. Fifth schedule in detail. So detail में first thing is this declaration. Very important. So who will declare an area as a schedule area? President. So you can write President may declare an area to be a schedule area. President may declare area as a schedule area after consulting the governor. After consulting the governor. Now executive power. Next is executive power. So executive power of the union extend to give direction. You can write executive power of the union extend to giving direction to the state. Extend to giving direction to the state on the administration of schedule area. On the administration of the schedule area. Third important, tribal advisory council. Okay. So यहाँ पे members can be up to 20 members. Up to 20 members. जिसमें 3/4 being the scheduled tribe members. 3/4 should be ST MLA only. MLAs of that particular जो states है वो 20. 3/4 correct. 3/4 being the scheduled tribe MLA of that particular state. Like Jharkhand, if we are making in Odisha में whatever the MLAs are there, जो इसमें 3/4 जो up to 20 members, we can suggest anything like 16, 18. 3/4 should be those MLAs who belong to the ST category, correct? You will get that much because reservation is there. Okay. So what is the purpose of this? To advise on tribal welfare. To advise on the tribal welfare. To advise on tribal welfare. So this is not a decision making authority. This is just a advisory body. Now governor's power. Governor's power. So here you can write governor submit an annual report. Governor submit an annual report. Governor submit an annual report. Sorry, नहीं governor's power. One thing. Governor's power क्या हुआ? Governor may direct whether particular state and central law will be applicable in that area or not. So you can write governor may direct that a particular center or state law. Governor may direct that a particular central or state law shall not apply to a scheduled area. To a scheduled area. Basically, a protective tool has been given to the governor. And governor will submit report to whom? President. Correct? So this is the fifth schedule areas. What are the states are there in the fifth schedule areas? Andhra Pradesh. Then we need to add Telangana together. This is how we can remember. Then Chhattisgarh. Chhattisgarh came out of MP because of this region only. So Madhya Pradesh will not be. Then for example Gujarat and Himachal Pradesh also will be there. उसके बाद झारखंड और इसके साथ आप ऐड कर लो MP also. Okay, this also. देन झारखंड, उड़ीसा, ठीक है, और कौन सा स्टेट है, राजस्थान, महाराष्ट्र, राजस्थान, महाराष्ट्र। सो टोटल 1 2 3 4 5 6 7 8 9 10 हो गए, 10 states are there. In these 10 states में फिफ्थ शेड्यूल एरियाज आर देयर, ठीक है, लाइक दिल्ली में नो शेड्यूल एरियाज, पंजाब नो, बिहार इज ऑल्सो नो, यूपी एंड बिहार नहीं है, ये ध्यान रखना, ये लिख लो बड़ा बड़ा, यूपी एंड बिहार इज नॉट हैविंग ए शेड्यूल एरिया। Done the 10 states. Next is sixth schedule. Sixth schedule. So sixth schedule is based on Bardoli committee. सबसे important है. It is based on, okay, it is based on the Bardoli committee of Constituent Assembly. Correct. So this is applicable in 4 states. Total 10 autonomous district is there. In 4 states में total 10 autonomous districts are present. So we'll be having autonomous district council here, autonomous district council, ADC. Each has up to 30 members. Up to 30 members. 26 elected and 4 nominated. 26 elected and 4 nominated by governor. They are elected for 5-year term. Okay, so they enjoy legislative, executive and judicial power. These council, so they enjoy legislative, executive and judicial power. Correct? Fifth schedule is not having these powers. So for example, they are having law making power. Law making power. These councils are having legislative power. So these councils can make law on land. These councils can make law on land, forest, forest में except reserve forest. You can write forest में, you can write except reserve forest. Reserve forest, that will not be included. Okay, canal water, shifting cultivation, shifting cultivation, sometimes even June. Okay, village administration, marriage and divorce, marriage and divorce, social custom. Shifting cultivation is also called June, village administration, marriage and divorce and social custom. But one thing we need to make sure कि आपको लगे कि they are having too much power ना, subject to governor's consent. Whatever the law they are going to make, they have to take consent of the governor, subject to the governor's consent. Financial power they are having. They are having financial power. Financial power. So financial power में for example to collect tax, to collect land revenue and impose certain taxes. Collect land revenue and impose certain taxes. Judicial power also they are having. Judicial power is also there. Okay, so that is fifth and sixth schedule done.
So they have lawmaking power only on those
Yes.
nothing related to it, as you said, criminal.
No, that is not. Clear, are we done? Okay, so this is done. Okay, we have done complete everything. Now rest of the things again one more class is required extra के लिए. Otherwise if you see last 5 years papers, they are asking one or two questions, but this year they have asked 3-4 questions from here. One more class we can have on constitutional amendment, constitutional doctrines, and rights of vulnerable sections like children's, women's. Okay, these rights basically governance side only, and then that is more than enough there. Correct. 3 to 4 questions were easy also. Polity, what were those questions? Article 13, it was easy or difficult? It was too easy, plain x and y. Okay, y was right, x has not completed class properly, so he is not aware about last part only. Okay, so easy tha ye. Second was I think this devices of parliamentary proceeding. Question hour, star and an star question statement just change कर दिए थे. That was also easy. और कोई question? Yes. Fifth schedule का question था that 2-3 times they have asked. और एक 395, 393, 394 last article. So they made paper by actually back side only. Front खोलना भूल गए थे, लाइट चली गई, पीछे से देख लिया बुक. ठीक है. So we will cover, but whatever the custody and everything we have already covered. One more class is required. After that, that is more than enough. ठीक है. Okay, so study well these things. Whatever already you have covered, just read those items also. So you remember, what is the ground for removal of vice president? ये तो simple question था. Ground for removal of vice president? No ground. What is the majority required to remove vice president? What is effective majority?
Because of the present and
Present and voting. ये तो गलत हो गया.
then members.
Then members present and voting. Correct? पक्का? Yes. Total strength minus vacancy is equal to effective strength. Majority of that number is called as effective. अभी तो polity आपको easy भी लगने लगा. Multiple times you have covered. It will be easy only. But only thing what you have to do now, because multiple times you have covered now. After doing lot of PYQ and test, you will come to know there are some topics are there. They are completely unnecessary. So you need to leave those items whenever you are reading like fundamental right, DPSP duties, parliament chapter. Some of the pages will be there in the Lakshmikant or in the class notes also. आपको लगेगा this is useless. No one is going to ask anything. Okay, so just leave that part actually, so that you have to save time in important topics. ठीक? Okay, thank you.